Okay, let's continue. Any questions? No? Okay, good. Okay, duty of care, breach of duty of care. So under what situation the duty of care is breached? Now, a person owes his duty of care to another. Doesn't mean that he or she is tortiously liable. It only means that he or she is liable when the duty is breached. So you owe somebody a duty of care if you have not breached your duty of care, so then you are not liable. But if you have breached it, then there could be a problem. So how to test? Test if a person has breached the duty of care, how to prove, how to test. So an objective standard is adopted in the court if it is to examine whether the duty of care is breached. So what objective standard? We don't have an exact figure. Say out of 100 marks, is it 50 marks, 60 marks, or 40 marks? But in legal sense, we just have a reasonable man standard. So that means what? In considering whether the duty of care is breached, we will consider whether in such a situation a reasonable man would take that duty of care or will breach that duty of care or not. So reasonable, that means what? The majority, ordinary, most of the people, right? Not someone who is very special, who is peculiar, ordinary, reasonable. So duty is breached, the duty of care is breached when a person fails to do something that he or she would reasonably do, or has done something which a reasonable person would not have done. Right? So that's the art of studying legal matters, legal knowledge. So we don't have figures, we don't have numbers, but we just have descriptions laying down the principles. Fails to do something that a reasonable person would do, or done something that a reasonable person would not do. Okay? So what is a reasonable person? Not someone with special power, special knowledge, special courage, special wisdom, but just an ordinary person, the majority, the norm. Okay? As simple as that. But in some cases, special standards are adopted. If you still remember when watching the video, I stopped the video and highlight to you the case where children were involved. When it comes to children, we need to take special care. We need to adopt a special standards. When it comes to professional or skilled persons, for example, of particular relevance, people of specialist knowledge in the FM context who are professionals, then certain special standards will be adopted, rather than referring to the ordinary person standard in some cases, like dealing with children or professional or skilled persons. So it depends on the case, the situations. So professional standard like doctor, lawyer, judge according to the prevailing standard of practice in the field. So we need to refer to the normal, the prevailing standard in the field. Okay, what's normally being practiced. You may refer to the Bolam case. And then following the customary practice is not immune from tortious liability if that practice is itself negligence. So we could not say, oh, we just follow the customary practice. Most people have been doing that. We just follow the normal practice. If that normal practice is not a proper practice, if it is itself a negligence practice, then you could not rely on that. Okay? We can refer to normal practice if that normal practice is all right, not negligent, then you can. Okay? So you may refer to the Edward Wong Finance Company case. for this principle. So the expected standard not affected whether a starter or veteran. Starter meaning a green, say a fresh graduate, for example, who had just started a career, or a veteran, very experienced people, veteran, okay? Doesn't matter. But determining the required standards could be complex because real world situations are complex, okay? And not every situation could be identical to each other, right? And not, you could hardly find two identical cases. You could find similar cases, but it's hard to find identical cases, right? Therefore, it is difficult to rigidly fix a set of quantified criteria. Difficult. But the court will consider generally the following things. First, number one, whether the harm is foreseeable. How serious it is, how serious the harm is, and how much is needed to avoid it or avoid the harm, right? To determine the required standard for duty of care. Then again, if I ask you to just memorize these 3 points, you may be able to do so, but you may not be able to understand each of these points very clearly. That's why we also need to refer to some precedents. Now, the first point, whether the harm is foreseeable, foreseeability. We can make reference to knowledge available when the harm arises, not after, not after. Okay. So as illustrated in the Roe and Ministry of Health case, so what is it? The facts here, again, give you 2 minutes. Try to read and understand these facts, and I will explain them to you. Okay. And also the decision held. It illustrates the principle of foreseeability. Knowledge available when the harm arises, not after. Before I forget, there was a group sending me an email, right? Which group? Is that group here? Who sends me an email? Your group. Okay, now that case illustrate this principle. Knowledge available when the harm arises, not after. So the facts, now the plaintiff injected with anesthetic is a medical case, suffered paralysis, And then the anesthetic was stored in an ampoule, just a container, okay? You consider it as a small container containing the anesthetic, the medicine. So it was good to disinfect the ampoule. So that container was disinfected. But this process had a risk. The risk was that there could be some fine cracks with the small bottle, okay? Considering it as a small bottle container, which the small, fine cracks could be undetectable. But just looking at the small bottle, you could hardly spot some fine cracks, right, using your naked eyes, ordinary inspection. So then eventually the patient was injected with that as anesthetic, contaminated, mixed with carbonic acid. And that medical incident, the accident took place in 1947. Then after several years of trial, the case went to the court to trial in 1954. So that is what? 4 plus 3, 7 years later. And such risk became known at that time, 7 years later. They know that there could be such a risk. But before that, that means 7 years ago, 1947, must not look at the 1947 case because what? 7 years before the case was trial, back in 1947, normally, right, people would not be able to know such a risk of having fine cracks with that small bottle, ampoule, with that contamination. So it was held that it was not negligent for the doctor because we must not look at the 1947 case with the 1954 spectacles. That means now, I mean, at that time of the trial, 1940, 1954, the knowledge is known. But 7 years ago, there was no such knowledge. Okay, so that's why we should, when looking at knowledge available when the harm arises, not after its occurrence 7 years later. Okay, talking about foreseeability. Seriousness. Seriousness. Okay, it's the principle, the risk of greater injury requires greater precaution. So if you foresee that the risk is high, then you should take greater precaution to avoid having problems. Greater precaution. So the Paris and Stephanie case, now it was held that the defendant should have taken greater precaution for the safety of the plaintiff, who was a one-eyed man. Now, if you consider there's a high risk, you should be very, very careful. So if you are taking care of somebody who has some sort of disability, like in this case, one-eyed man, you should take special care, greater precaution. Okay, so it depends on how serious it is. And then the third point, in taking precaution, we also need to weigh and balance between the cause of precaution, the cause of avoiding the harm, and the risk of occurrence. So although it is not that easy, I would say it's not that straightforward, right? Because risk is not exactly cost. Cost, you know, right? Say you have to use $1,000, $10,000 as precautionary measures, but for risk, you could never know exactly, right? Whether, say, the accident could happen, we would be able to predict, estimate the probability, right? But so unlike cause could be quite exact, but risk, right? You can have risk level, but that level is a matter of probability. So as demonstrated in the Weifeng case, in that case, the defendant manufactured plastic doors, okay, plastic doors in a factory building. One evening, there was a fire. Fire broke out, right? Damaged the plaintiff's adjoining premises next to it, nearby. And there were 4 tons of plastic present on the 8th floor. Okay, plastic, and there was a fire. Depends on what sort of plastic. Right? It may help the spread of fire. Could be very dangerous. So it would have cost an enormous amount of money to store them in a special fire-resistant compartment. So if we will, right, to provide sufficient precautions, we can do so in that case by spending a lot of money, enormous amount, to store the doors, the plastic doors, in a special fire compartment, right? Say instead of storing it in a room with wall of 100 mm thick, you may store it in a room with 200, 300, 400 mm thick wall, right? But the problem is what? The cost could be very, very high. So we are talking about the point cost of precaution. So we have to weigh and balance between the cost of avoiding the harm and the risk of occurrence. So cost was very high. Then there was no such common practice in Hong Kong, just for storing the plastic doors. So it was held that D must take such precautions as were necessary, but not expected to spend an enormous amount to build fire-resistant compartments for storing 4 tons of plastic. Therefore, there was no negligence on the defendant's part. So all in all, this illustrates the principle of cause of precaution. So going back, to determine the standard required, we have to look at whether the harm is really foreseeable, how serious it is, and the cause of precaution, how much is needed to avoid it. Okay. Okay, another important principle is causation in tort law. Okay, cause. Okay, where are we? Going back. We are now here. Slide number 6. Remember, for a claim in tort to succeed, we have to establish the following conditions, right? Number 1, there was a duty of care. Number 2, the defendant has breached that duty of care. Now, number 3, we are now here. Whether that breach of duty has really caused the injury or damage. That's why we are talking about causation. All right? Number 3, causation. So if established that the wrongdoer has breached the duty, the next question is whether his negligence has in fact caused the injury, the third point in slide number 6, okay? Causation. So to make this judgment, use the but-for test. But-for test, what does it mean? Meaning, you have to ask one question. Would the injury or damage not have occurred but for the negligence of the defendant? So the other way around, the damage occurred because of the negligence of the defendant. And this is the question. The statement I've just made is the answer. Okay? So you have to ask this question. And this question is, in legal sense, we call it the but-for test. But-for, okay? Here, but-for, okay? A causal link is established if the answer is yes to this question is yes. Barnett and Chelsea case. Okay, we have a short video showing the but-for test, causal link.
discuss the differences between but
But
for
for
and
test.
substantial factor causation. And these are really just two types of tests that many courts use to determine whether a defendant caused damage or injury. So let's say we have a defendant here, and he takes an axe to a tree which is right next to a car. The defendant foolishly chops down the tree, damaging the plaintiff's car. Well, in our lawsuit, the plaintiff is going to have to prove that the defendant caused the damage to his car. And this is also a good example of but-for causation. Meaning if the defendant had not taken the axe to the tree, let's say he just decided to make a phone call instead, the car would be just fine. The tree would not have fallen on the car. A jury is likely to conclude that but for the defendant's actions, the car would not have been damaged. For that same reason, a jury should conclude that the defendant was responsible for causing the damage to plaintiff's car. On the other hand, let's say we have a plaintiff who has a bad back, and he wants to sue his employer, who he says forced him to carry these big boxes. But the plaintiff also played football, and he enjoyed lifting weights. So was the bad back caused by lifting boxes, playing football, or lifting weights? Maybe all of these factors had a role in causing the injury.
So the picture here, injury is the end result. That could be due to several things, right? Playing games, weight training, or carrying heavy stuff, right? So, but which one has really caused the injury, right? Is the causal link.
In causing the injury. So of course our employer will say, look, even if he hadn't lifted the boxes, he still would have ended up with a bad back. So we can't say that but for the boxes, he wouldn't have been injured. Therefore, the employer didn't cause the injury. The plaintiff might not be able to prove but for causation. However, he might be able to prove that lifting the boxes was a substantial factor in causing his injury. The defendant can bring evidence that lifting the boxes was at the least a substantial reason why he was injured. The court will require proof as to how lifting the boxes was a substantial factor. Looking at another example, let's say lightning causes a forest fire, and our defendant for some reason decides to throw a can of gasoline into the fire, and eventually the forest fire destroys plaintiff's house. Well, the gasoline must have contributed at least a bit to the forest fire, but even if he hadn't thrown the gasoline, the forest fire would probably have destroyed the house. In this situation, we might not have but for or substantial factor causation. The house would have burned down even if the defendant didn't throw the gasoline.
Right. The house will have burned down even if defendant did not throw gasoline. Okay, in this case.
So
we don't have but for causation.
And the gasoline really contributed to the forest fire. So we can't say the defendant's action was a substantial factor in causing the damage to the house. If you'd like to discuss causation or any other matter related to U.S. law, stop on my website on law and
Okay, now this is a similar case, illustrating the but-for test, whether there was a causal link. In that case, you have to look at the timing and also the parties involved. Now, the plaintiff's husband, who was a watchman, okay, vomits persisted until 8 a.m. Now, at 5 p.m., it occurred at the beginning, 5 a.m., and then 3 hours later, that watchman vomited, right? Felt sick and went to the casualty department of the hospital, okay, after 8 a.m. But they were not seen by the doctor. The doctor on duty himself was sick, okay? So that means there was a delay for medical treatment, medical consultation, okay? Then what they were advised to go home and call in their own doctors to see their own doctors instead of seeing the doctors at the hospital. Then the plaintiff's husband died in the afternoon, 2 p.m. Okay. So the question was what? Whether the death of this watchman was due to but for, right? Died but would not have died but for the delay of seeing the doctor in the hospital. It was held that the defendants casualty officers were negligent. Why? The plaintiff had failed to establish her claim that the death of her husband resulted from the defendant's negligence. Now, why? Because even if all care had been taken, the deceased would have died anyway. So assuming, say 8 a.m., when these guys, including the watchman here, receive medical consultation by the doctor in the hospital, the case was so serious that the watchman anyway would have died. Okay? So even if all care had been taken, the deceased would have died anyway. So it was not due to the negligence that the watchman died. Okay? So therefore, we have to look at the timetable. The timetable is of much importance. Attended the hospital department, the deceased attended the hospital at around 5 or 10 minutes past 8, okay, in the morning. And then before 11 a.m., right? And then before 12 noon, and then after 12 noon, we have to look at the sequence of events. Okay, as I said, anyway, it was a serious case, even if he could be admitted to the hospital and he was given the chance to see the doctor. This was so serious that he anyway would have died. It was not due to the negligence. Okay, multiple of or consecutive causation. If you still remember the picture, I stopped the video. The injury, there could be several causes, right? Multiple causes, multiple causation, or consecutive causation. Now, it is not straightforward. It's a matter of degree because we could be due to the death could be due to several issues, several factors. Now, maybe I can show you a diagram that can help your understanding. Okay. Okay. So the picture here, say someone died, death. Okay. And that guy could have several issues already with problems with his or her body. Factor A, he got heart disease. Factor B is also diabetes. Factor C, due to collision, car collision. Okay. So in an incident, that guy already got heart disease, already got diabetes, but unfortunately now encounter a accident, car accident, collision. Then all this could contribute to the death of that guy, right? But which of these actually is the substantial factor causing that guy to die? Collision may be making him panic, right? Suddenly heart disease, okay, leading to, say, problem with the heart functioning. So there are originally multiple causation, but there may be one causal link if this is the most serious and direct factor leading to the death. Okay. It's somewhat like, say, when you're studying electrical installations, right? We have parallel circuit, like the case here. Consecutive causation. We could have several events before injuries or death of somebody. We can have event 1, event 2, event 3. finally leading to the injury. So what are these events? In a later case, I'm going to show you. You'll find there could be some cases involving multiple events consecutively, causing the final injury or death, like series circuit, right? Okay. So how to determine, right, the causation? The approach in determining this, instead of a philosophical, scientific, or medical theories, the court will take a common sense approach. Consider all the relevant factors before making the judgment. Okay. So this is a case that is not uncommon, I would say, that could arise, that could occur in management, facility management in buildings. The case was that the plaintiff was an attendant in a car park. The defendant drove his van into the car park, and then the defendant has no parking permit, but still insisted to go inside the car park. The plaintiff was told him to leave. And then what? The defendant refused. They argue, right? They argue. The defendant then attempted to park the car despite the plaintiff's objection, still insisted going inside the car park. They argue, okay? Defendants reserved the van negligently and hit the plaintiff. The impact of the plaintiff was trivial, not big, just a small hit, okay? But what the plaintiff suffered intracerebral rupture, resulting in a stroke, could not move, certain part of the body, stroke. And what triggered that hit, triggered the stroke because of a sudden surge of blood pressure. So an issue was whether the collision, the car hitting that guy, really caused the plaintiff's medical condition. You remember that it's a small hit, trivial. It was held that the plaintiff had to establish the causal link between the defendant's negligence and the damage. The plaintiff's blood pressure, which brought on the rupture, was caused by the excitement. Because what they argued, right? They argue causing maybe high blood pressure and then subsequent problems, right? But may not be due to the heat. Okay. So we are talking about different causes. It was held that no way it could be singled out as sole separate cause leading to the injury. So the plaintiff's claim failed. There were multiple causes, and it was not possible to single out, to identify a single sole cause. Therefore, failed to establish the required causal link. Okay, multiple causation, multiple causes. Consecutive causation, I show you my diagram, right? Multiple events, one after the other. Claims can be made not only to the first tortfeasor. First tortfeasor, that means the first party doing wrong, the first wrongdoer, okay, causing the tort issue. There could be multiple, the first one, the second one, the third one, okay? Claims could be made not only to the first one, but also to the second or the third one, subsequent ones. I show you my diagram. I can show you again that diagram. Multiple, the first one, the second one, the third one, right? In series, as illustrated in the Baker case. So what was that case? Again, here are some facts. Okay, 1 minute, just look at these facts, then I will highlight them to you. Okay, now how many events here in this case? Number one, the plaintiff was knocked down by D's negligent driving, okay, car accident. Then what? P suffered stiff leg. That was the first incident, first event. And then, but before the trial, the plaintiff was what? Unlucky, right? Suffer another incident, was shot in the same leg in the robbery. The first incident was a car accident. The second incident was a robbery. Okay, shooting on his leg, on the same leg. Okay, then eventually his leg has to be cut, amputated, cut. Okay, then the defendant argued that he was not liable to the plaintiffs because what? Because the second injury should have obliterated the effect of the first event, like supersede the effect of the first one. The first event was negligent driving. The second event was robbery. Okay, but it was held that the defendant remained liable. The subsequent injury, the second injury, shooting on the leg in the robbery, did not reduce his loss. Okay, there were two events. Remember, in series, consecutive. So a man is not compensated for the physical injury, he's compensated for the loss which he suffered as a result of the injury. The first injury, now we are claiming the first tortfeasor, the first wrongdoer, tortfeasor. Okay. The second injury did not diminish any of these, did not diminish the first one. Okay. So that illustrates the principle. Okay. Subsequent ones, consecutive causation. Okay, this one is what? The principle of, again, this is not ordinary English, but if you wish, you can pronounce it as novus actus interveniens. What does it mean? A break in the chain of causation. You know, we have a chain of causation. If there is a break somewhere here, a break in the causation, then the original tortfeasor is not liable for the extra damage. So say here, the first incident was the negligent driving. The second incident was shooting on the leg, right? Right. If there is a break here, the first tortfeasor is only responsible for the damage due to the first incident. Okay. Original tortfeasor not liable for the extra damage. So to claim to use the application of this principle, it must be outraneous. That means spontaneous, voluntary. Something unwarrantable or unreasonable. And what? The subsequent wrongdoer may include the plaintiff himself or herself. You know, in an accident, say in the case here, sometimes the injury, the damage may be due to the defendant, but may also be partly due to the plaintiff himself or herself. If the plaintiff himself or herself has done something wrong, right? So the wrongdoers could be partly due to the defendant, could be partly due to the plaintiff himself or herself. Subsequent wrongdoers include plaintiff himself or herself. Okay. So you may read this case, and the plaintiff's deliberate attempt, that case is what? The plaintiff deliberately attempts to light a secret. Say if you are in a building, which is a dangerous goods store, DG store, there's already a notice saying no smoking, right? Because if you smoke, there could be risk of explosion or fire. But if you do not follow the instruction, you do not listen, do not stop smoking, deliberate attempt to light a secret, then the consequence could be partly due to yourself, right? You could be the wrongdoer. Okay, causation in law. Now again, I will reserve this to be explained to you after the break and together with the in-class activity. As I said, I will allow you around 30 minutes to do the in-class activity. But here I really need to, I think, as I mentioned earlier, I really need to highlight to you because I spot check some of the cases you identify. I found that they do not comply with the requirements here. Now, this is the in-class activity, search and review of law report. The case should be between year 2000 up to now, any case, but the length should be between 3,000 words to 9,000 words or 12 to 25 pages. Not too long, not too short. Okay. And you need to submit 2 files. Okay, not 1 file. What are the 2 files? Number one is the form completed by you. Number 2, the law report you identified and you selected. And in this law report, you should highlight 5 key points, maybe 5 paragraphs or 5 lines, whatever, showing the key points. Okay. And in the form, you just need to write summarizing 1 paragraph, 40 words, summarizing 1 key point. You highlight 5 key points in the report. You submit the report. Okay. You summarize 1 key point in the form. Understand? Okay. Now, I already spotted at least 1 group failing to comply this requirement. Okay. The other groups you also have a check. Okay. On the case you have identified. Okay, one more thing is, if you look at the timetable, we are now here. 9th of February, right? Tonight. Next week, no class due to the Lunar New Year break. Then we have 2 more lectures to be given by my friend, the solicitor, William. One on tort law, the other also on partly on tort law and statutory building management matters. Okay. Then when we meet again on 9th of March, there will be a test. Okay. I would send out an announcement very soon, but now I would like to orally brief you about the test. The test will cover the lectures before the test. Okay. And it will be a multiple choice test. 20 multiple choice questions, 20. Half an hour. Okay. Closed book. Okay. Will be held in this classroom, not online. Okay. Physical. So remember to bring at least a pen, right? To write your answers, pick your choices. Okay. So about the test, to help you have a feel about what the test could be. Here are some sample questions. Okay. For example, a simple question could be, so in contract law, an offer may be terminated by what? Answers easy, right? You can find it from the lecture notes. So, but you remember it is a closed book test. Okay, you have to study, you have to do revisions before the test. What's the answer? A, raise your hand. 1. B, raise your hand. C. D or E? Okay, a few more. Okay, what's the answer? This should be B. Boy. So another question. What do you think? A, raise your hand. B. C. 1, 2, 3. C. D. D. E. F. Don't know. This should be E. Okay. The third one, I show you the answer. Which of the following best describes duress in a contract? Situation where one party is forced to enter into contract against the will by the other party. Okay. So these are just some sample questions, right? For you to have a feel about the style of questions you may come across. So 20 multiple choice questions like these, half an hour should be more than sufficient time. Okay, let's take a break, and I will give you around, say, 30 minutes for the in-class activity so that for you to search and review the law reports and make sure the law reports comply with the criteria I've just mentioned. Okay, so we will resume our lecture around 9 o'clock.